Um, yeah, so I also just thought I would give a bit of an update. Like, seriously, anything that can happen to a person has pretty much happened to me. I have not yet been attacked by Bigfoot. I don't know when that's scheduled yet because the scheduling guy is clearly just like there's an anti-comms team about which unlikely but guaranteed to happen disaster is going to make its appearance in my life. But I've emailed CMM at so the thing is that I'm unrepresented, and there's a reason for that. Anyway, I'll just read, and I don't even know what CMM stands for. It's got I think it's at criminal court. I don't know what the MM is. I'm not sure, but that seems to be the place you might put files on. Anyway, I don't know, but I've just said hi, this person at CM, and I said, what's the plan? Because on the 5th, so I left hospital. I'll just read actually. So I left hospital the morning that I was taken there by the cops because that was the day I was supposed to have my fucking kangaroo court trial, and that's when I did as 3 hospital staff who were trying to stop me from leaving said would happen. I did sort of collapse, like I had a bit of a faint, but I got down on the ground. I kept shouting at everybody. I should really have not shown my face here because this is not what I want to show. But it's okay, I'll link it together in a minute. Yeah, so this is how court works, honestly. And so I've replied. I've sent another email to CMU, and I have made I have put a little section from Idiocracy in there because Idiocracy is no longer funny. It's really not. So so I asked them for the judge's minute. This is on the 15th of February. I said, the judge's minute, please. I don't know the date of the next clusterfuck at court. I turned up to my trial and it wasn't a trial. Oh my god. And no one notified me. This is incompetence and illegal. So is the next trial date or whatever the hell it is, it turns out to be. So when is? And then I hear back from CM and good morning, Caitlin. Judge did not issue a initial direct transcription from your most recent hearing on the 12th of the second. However, I can tell you the next appearance scheduled as 5th of March in our list court. So that just means that I've just got to sit and wait for my name to be called in front of everybody else, usually drunk drivers. This means it's not the trial date, it is a date for the judge to be updated on the assessment that was ordered, the psych assessment, which I had said to them, well, they may as well do the assessment while I'm in hospital, considering the assessment's done by the same people, just that one's going to be naturally deployed because I tried to take my life, and the other one would be because it's court ordered, and you could always amalgamate the two or whatever. I mean, between Ministry of Justice and the District Health Board do take turns with a brain cell, and maybe they could use the brain cell at the same time and come up with a plan. That was my idea anyway. I said, oh, okay, thanks. See, and then I said, I really do wish that this information was given to defendants. When I just got an adjournment date written on a business card. That's not sufficient information, and I lost the business card as I was on my way back to hospital where I collapsed several more times and vomited on myself and shat my bed. Horrible communication method. I had left hospital against the wishes of hospital staff to attend the trial, which no one told me wasn't a trial, so that a warrant for my arrest wasn't issued. This was against the wishes of hospital staff because I was likely to collapse. I had very low blood pressure, at lowest about 80/50. People can stroke out on BP that low. You don't want to go lower than 90/60. I did collapse in court though I saw it coming and got down on the floor before actually fainting into a passed out stage. It was very dangerous for me to have come in court, but court ignores or dismisses the Human Rights Act. So as far as the psych assessment went, one, the judge said in court that the psych assessor would be from the DHB as with any other public psych assessor. I said in this case he or she could conduct that assessment while I was in hospital. Two, the man in his late 60s or so I thought was a duty lawyer but said he was an administrator or similar, who escorted me to the courtroom when I arrived, elaborated a bit on the court order for the assessment. So I gave him my hospital number so the assessment could be done while I was in hospital. And I put in big letters. Because I was in for a suicide attempt, I was going to get a psych assessment anyway because that's standard procedure. I also was under constant watch by successive members of the security team. No one saw me there under court order, and A, I was there from Monday morning till Wednesday afternoon when I self-discharged. B, I was seen by a mental health nurse on behalf of the crisis resolution team on Tuesday, which would be the same place that the court-ordered psych assessment would be deployed, and it would be a psychiatrist, I imagine, not a nurse. See, on Wednesday I was seen by another mental health guy. Not a psychiatrist, I'm sure. I told him I was unable to keep repeating myself in linear interviews as this is the opposite of trauma-sensitive care and simply impossible for me. He accepted I wasn't going to talk to him and never said he was there in court order, and I had to talk to him. 3. I put screeds of medical, including psychiatric material, on the court records. This is ample for the judge to see or for an assessment review to be made. Every time I get a psych assessment, that's number 4, multiple times in Christchurch after my releases from the Mental Health Act and Helmorton, I get cleared, most recently in November. As an SB5, as an SBO, I interview poorly psychiatrically as I tend to report on the facts of my circumstances and condition emoting. 5B, because I've been hoping for a full neuropsychiatric and physical checkup, I've been recording my poor conditions in vivo. I include these in the Dropbox folder. These should be used for assessment. Interviews are a ridiculous way to get a gauge on someone's mental health. 6, as I said to the mental health guy, Mark, the Mental Health Act is explicit that self-harm is not a subset or symptom of mental disorders. Both that risk of harm and a suspected mental health disorder need to be present for a court order under the Act and need to be present to be held under that Act. So why do judges and mental health staff, specialists straddling that Act, not recognise the distinction? 6A, I was released by a psychiatrist because I was found to fail one of the 2 conditions to be held, and it was the mental disorder. I was released with a mod high suicide risk, that same risk as on my medical certificate for NSD. This again is the link to my Dropbox folder I've sent you in J80, which is the judge alone trial, something or other, with my medical information that the judge should have and seemed to have no idea about. I will continue to update as indicated. And so she replies on the 16th, the next day, the day after the trial and the day after I emailed that. Hi Caitlin, thank you for the update. I have printed a copy and placed it on file so the judge can read it as you have laid it all out. Unfortunately, we cannot access the Dropbox via a computer system, nor can we attach videos or audios to the physical file for the judge. So, I bet when you get that brain cell, the week you have that brain cell, you can figure out how to get the judge to listen to it without attaching it to a file. I bet you can. I believe in you. I replied, thanks Olivia, Okay, so the judge is missing out on vital information by excluding the AV evidence. That means that the evidence he or she sees is incomplete and will compromise the status of the truth. I can't be held responsible for this unjust and illogical decision, and I at this stage refuse to suffer for it. If that psych assessment comes to be, then the assessor must see and hear the AV evidence before I see him or her, or we can watch or listen together. I'm not answering more questions. Groundhog Day is over. Thanks, Caitlin. And then I said, oh, if you can't access Dropbox folders, can you access others, or should I attach my documents to successive emails? And I go to a list of all the documents, so and their name, I name things pretty adequately. And there's no reply, so I said, hi, I guess the cat's out of the bag now, Olivia. I attached my updated MedCert for WIN supported living payments. I attached also screen caps of the contents of the Dropbox folder. This includes the mental health assessment and much else of relevance. As sneaky people do, they reply to emails that behoove them best to feign ignorance. So instead of replying to that last email that I'd sent, which was sent at 11:07 and she replied 11:14, she replied to my 10:51. Oh, if you can't access Dropbox folders, can you access others, or should I attach and document successive emails? So I sneakily, without indicating, because I think I'm perfectly, if she's going to be sneaky, I'm going to be sneaky, I just inserted my email, which she had neglected to reply to, in which I had attached one of my medical documents. Anyway, so she says, if they are attached as a Word doc, PDF, etc., we should be able to open them, but we can't access shared online drives. And then I said rather dryly, I would imagine that a government department can open Word docs and PDFs. I think so. I think memorandums and minutes, I think they're usually portrayed in PDFs or Word docs. I don't think the TikTok dances or PowerPoints or any sort of tribal sort of ceremonies. I'm pretty sure it's PDFs or Word docs. Yeah. I said, can you open the PDF below? And she never replied. So today I wrote, so that was the 16th, that was the 27th. So today I wrote, hi Olivia, what's the plan? Psych assessment on the 5th of March. It's now the 27th, so the psych assessment list case review things in 1 week. I said it's now the 27th and I've heard nothing from court about the plan for 5 March since you told me on the 16th below that the judge would be looking at my psych assessment, followed by my strong recommendation that he or she looks at the ones that should already be on the file. No one has approached me about a psych assessment or about court, and with the review of the documents set for 5 February, in 1 week, I feel it's time court tells me what's going on. I'm still concerned about the court's fixation on my psychiatric status when the overriding legislation is found in the Human Rights Act and the Bill of Rights Act. Police have barely attempted to pretend to follow the Policing Act or the Criminal Procedure Act, and court seems entirely unbothered by the clearly lacking documentation and evidence provided by PPS, Police Prosecution Service. I get the feeling from previous contact with case review hearing judges that if I were to argue this, the burden of proof would be put on me, which is not how the Evidence Act works. A great disadvantage with no legal rep. No, I am not to blame for this. If my lawyer breaks the rules, by which I mean the rules of the Lawyers and Conveyancers whatever act, there are rules set out from that act, so it's the law. The rules come from the law. It's like secondary legislation. If my lawyer breaks the law by flouting the rules, I do not have to and should not retain him or her, and have had my questions about getting an amicus curiae ignored. Again, amicus curiae means friend of the court, and it's really just to assist an unrepped or a self-repped defendant, possibly prosecute. I've got no idea, but anyway, because I guess they call it a friend of the court, probably because it doesn't really work for the court to have some brain damaged, traumatised person wandering around not having a freaking clue what's going on. Surely a review of process or indeed an investigation into CPA, Criminal Procedure Act misconduct is warranted, if not in fact underway. Can you please update me? And then I followed with, I also wanted to make another point since the judge didn't create a minute. He sternly told me that Claire was my counsel until he released the contract, which he did straight after. Because I told him, I was like shouting at Claire, "You are not my counsel." She turned up. It's like, what the fuck did you turn up for? Like, you're over, lady. So the judge sternly told me that Claire was my counsel until he released the contract, which he did straight after. I believe this is untrue. I didn't bother firing Claire. I cancelled my contract with legal aid. A legal aid lawyer-client relationship cannot survive this legal aid contract cancellation, I believe, as it's managed by the LSC, Legal Services Commission, not the court itself. The reason I left legal aid, and yes, I copied Claire into that cancellation, was because I couldn't have found more idle counsel amongst the homeless huddled at the bus interchange. It's a shame that hearing on the 12th wasn't recorded, because Claire's lack of understanding of the charges was expressed by her so eloquently. According to Claire, the 4 July charges to be heard on that day were that I resisted being trespassed by my property managers. I was shocked, but at least I had an audience to her lack of legal capacity. She also made ad hominem attacks on me, saying I was too stubborn and perhaps traumatised to accept the charges, which was not just an affront to the proof she never looked at, but also the dirty charges, which are unrelated to my property managers. They involve my neighbour. Legal aid is dangerous. It's like having a second prosecutor. And then I put in the idiocracy. I didn't spend ages trying to edit it down. It was pretty perfect for my purposes, but I just put in idiocracy courtroom scene. And this is just so, honestly, apart from the dialect, this is fucking how it works. It is funny, but it's only a funny because it's true. Yeah, so yeah, this is like the stupidest way, but otherwise I've got to like try and splice that together.
Had become rather retarded as well. I'm fixing to commensurate this trial here. We gonna see if we can come up with a verdict up in here. Now, since y'all say...
By the way, I've always thought that I look like the female version of Luke Wilson. Not all the time, but I bet you can sometimes see it. By the way, I think he's really... I'm kind of madly in love with the guy.
You ain't got... Joe was arrested for not paying his hospital bill and not having his UPC tattoo. He would soon I'm fixing to commensurate this trial here. We gonna see if we can come up with a verdict up in here. Now, since y'all say you ain't got no money, we have proprietarily obtained for you one of them court-appointed lawyers. So put your hands together and give it up for Rico Pendejo. You're my lawyer?
Says here you, robbed a hospital? Why'd you do that?
To anyone who hasn't seen Idiocracy, that was also his doctor. Oh no, shit, no, not his doctor, sorry. It was Justin Long. Sorry, no, he was the guy whose house he crashed into when his cryogenic pod fell off into his house. Sorry.
You're my lawyer?
Says here you, robbed a hospital? Why'd you do that?
Yeah, I'm not
guilty.
That's not what the other lawyer said.
I mean, listen, you gotta get me on the stand, okay? I can explain everything. We can take him to your house. We'll show him the pot that I came here.
Shut up! Prosecutor, why you think you done it?
Okay, number one, Your Honor. Just look at him.
He talks like a fag, too.
And B, we've got all this, like, evidence of how, like, this guy didn't even pay at the hospital. And I heard that he doesn't even have his tattoo. I know. And I'm you gotta be shitting me. But check this out, man. Judge should be like, guilty. Peace.
This is such a genius movie.
What are you objectifying on?
Come on, just get me on the stand.
Okay. Your Honor, I object that this guy also broke my apartment to shit. Yeah. And you know what else? I object that he's not going to have any money to pay me after he pays back all the money he stole from the hospital.
Don't say I stole. You're my lawyer.
And I object that he interrupted me while I was watching Oh My Balls. That is not okay. I rest my case.
Your Honor, I'm pretty sure we have a mistrial here, sir.
I'm going to mistrial my foot up your ass. You don't shut up.
Please listen.
Please listen.
I didn't steal anything. I was part of an army
Joe
experiment.
stated his case logically and passionately, but his perceived effeminate voice only through big gales of stupid laughter.
You did!
Without adequate legal representation, Joe was given a stiff sentence. Meanwhile,
let's find a way to reach your goals.
Yeah, and I get a little glimpse into what's going to happen to me as well. Seriously, like, because the prosecutor was there as well, and she's a lying scumbag, and basically she and Claire were both saying that I was just, like, firing nonsense at them. And the prosecutor said that I had just, like, submitted a lot of third-party testimony. I had submitted 0 third-party testimony. I don't have any third-party testimony. Like, and it really is, like, I really do struggle between the difference between incompetence and malevolence. Like, I really do. And it's not to say that both can't be had at once, but it was just like, I've got 2 prosecutors here, and they're both just, and you know, like, I just, like, for fuck's sake, do you see why I just want to die? Because what happens at the end of this movie is, like, his well, it's kind of like a second trial, but it's a sentence as well. he's got to go into, like, a monster truck, sort of indoor arena, and basically try to survive these fucking huge lifted trucks with gigantic fucking tire wheels. Driving like a Honda Civic or something with a big purple dildo flopping around on the front. And I see that in my future. I really do. Maybe I should just change my whole attitude to this and just go, let's just come along for the ride, man. And like, I do have some quite funny outfits. I think I might go and dig out some of my dress-ups, because I do still have dress-ups. I might go and dig out some of my silly outfits just to reflect the gravity of the circumstances.